Have you ever wondered if your boss can actually fire you over something you posted on social media? Imagine this, you're scrolling through Facebook late at night, frustrated about your job, and you decide to vent. Maybe it's about your manager being incompetent. Maybe it's about how underpaid you feel. Or maybe it's a political post, a meme, or an off-color joke. You hit post, forget about it, and go to sleep. The next morning, you get called into the office, and before you know it, you're packing up your desk, wondering if your First Amendment rights meant nothing at all. Welcome back to Due Process Daily, where we break down law, politics, and your rights in plain English. So can you really get fired for what you post on social media? The short answer is yes, but the longer answer involves understanding employment law, free speech limitations, and how these viral terminations unfold. Let's start with the First Amendment because that's what everyone loves to cite when they're in trouble. The First Amendment protects your right to free speech from government censorship. It does not protect you from consequences by private employers unless certain exceptions apply. If you work for the government, your employer is the government, so the First Amendment does limit how they can discipline you for speech. But even then, there are nuances. For example, if you're a public school teacher and you post hateful speech or something that undermines your ability to do your job effectively, courts have upheld discipline or termination in those cases. If your speech disrupts the workplace, undermines trust, or threatens public confidence, your public employer can act on that. But let's say you work for a private company. The First Amendment doesn't protect you there. Private employers can usually discipline or fire you for posts they believe harm the company's reputation, violate policies, or cause workplace disruption. Many people don't realize that employment in most states is at will. That means your employer can fire you for any reason, no reason, or a bad reason, as long as it isn't an illegal reason, like discrimination or retaliation for protected activity. Some states have off-duty conduct laws that protect employees from discipline for lawful activities outside of work, but these are limited. For example, Colorado and California have laws that provide some protections for off-duty legal activities. But even then, if your social media post violates company policy, threatens workplace safety, or damages the employer's brand, you might not be protected. Another layer is the National Labor Relations Act, or NLRA. This protects employees who engage in concerted activity, which includes discussing wages, hours, and working conditions with coworkers, even on social media. So if you're complaining about how little you're paid and your coworkers chime in, that could be protected under the NLRA. But if you're just ranting about your boss being an idiot or posting discriminatory, harassing, or violent content, that's not protected. We've all seen viral terminations online. The woman who posted a racist rant about her Uber driver, the man who filmed himself harassing a fast food worker, the employee who posted a TikTok mocking customers with disabilities. These posts go viral, people identify where they work, and within hours the employer issues a statement condemning the behavior and announcing the termination. Why? Because employers know the court of public opinion is brutal. They also know that in many cases, these employees have violated social media policies that prohibit conduct harmful to the company's reputation. But what about political speech? This is a common question. Can you be fired for supporting a political candidate or cause? In many states, yes. Private employers can fire you for your political beliefs unless your state has a specific law protecting political activity. California, New York, and a few others have laws that protect employees from retaliation for lawful political activities. But even then, if your post violates harassment policies or creates workplace disruption, you might still face discipline. Think about the January 6th riots. Many employees who were identified as participating were fired, even if they didn't commit violence. Employers often stated that their actions undermined the company's values and reputation. Or consider the recent viral firings of people posting hateful comments after political events. Even if it's off-duty speech, if it's hateful or threatening, your employer can act to protect their workplace culture and brand image. So what can you do to protect yourself? First, understand your company's social media policy. Almost every employer has one now, and it usually prohibits posting confidential information, harassing coworkers, or engaging in conduct that could damage the company's reputation. Second, if you're a government employee, know that your speech still has limits, especially if it undermines your job effectiveness or public trust. Third, be mindful of what you post. If you wouldn't want your clients, or your grandma seeing it, don't post it. Privacy settings are not a shield. If someone screenshots your post, it's out there forever. Fourth, if you're posting about working conditions, pay, or workplace safety with coworkers, that could be protected under the NLRA. But again, personal insults, threats, or discriminatory remarks are not protected. Let's also talk about defamation. If you post false statements about your employer that damage its reputation, that's defamation and you could be sued. For example, claiming your company engages in illegal activities without proof could lead to a defamation suit. On the flip side, if you post truthful statements about workplace safety concerns or harassment, that could be protected whistleblower activity, depending on the context. One of the biggest misconceptions is that social media is your personal space, immune from workplace consequences. In reality, social media is public by nature. Employers conduct social media background checks before hiring. Courts have ruled that if your account is public or if coworkers share your posts with management, there is no expectation of privacy. Think about it this way. Your personal brand online is part of your professional brand, whether you like it or not. Employers care about how your actions reflect on them. That's why you see termination announcements stating, "This employee's views do not reflect our values." An immediate cutting of ties to protect their reputation. Now you might be thinking, isn't this unfair? Shouldn't free speech mean I can say whatever I want? Remember, free speech protects you from government censorship, not from consequences imposed by private actors like employers, social media platforms, or other private individuals. That's why people get banned from Twitter, fired from jobs, and still have no First Amendment claim. But let's not forget, if you are fired for posting about workplace discrimination, harassment, or unsafe conditions, that could be illegal retaliation. That's why it's important to understand whether your post was purely a rant or if it involved legally protected activity. If you think you were wrongfully terminated for social media activity that qualifies as whistleblowing or protected concerted activity, talk to an employment attorney. They can review your situation and determine if your rights were violated. In today's world, social media has blurred the lines between personal and professional life. What you post at midnight can cost you your job by morning. So before you post, ask yourself, is this worth my paycheck? Is this worth my career? Because once it's out there for good. Thanks for tuning in to Due Process Daily. If you found this video helpful, informative, or eye-opening, help us keep the channel growing by liking the video and subscribing to the channel. The information contained in this video is for informational purposes only and does not constitute legal advice.